While it might come in at a point of time from a certain social, economic, or an ideological understanding, if it has remained part of the constitution, it will receive that expansive meaning. But if it doesn't require that expansive meaning, because we say with the death of a particular ideology, we don't need this, to hang upon, then it's a different story altogether. It's a political story.
So isn't this a caveat against privatization and liberalization, which is the order of the day today? And where private enterprise is being encouraged. And as a result, the increase in private wealth would ultimately lead to the increase in the nation's wealth.
Absolutely. I'm not saying in the classic sense, the classic Marxist sense, you regulate everything, nationalize. I'm not saying that should be read in. That's the way it has, in fact, such constitutional provisions will receive wisdom and maturity in an evolving constitutional framework. So therefore, even we have a private expansive private market or private capitalism, whatever one may have, but this provision will still have a certain relevance.
So His Lordship Justice Krishna seems to be warning against what is the scenario today.
He wrote at a point of time when, with his own understanding of what would be reading into Article 13B. But I don't think that's only one index. It's one index of looking at 13B. But I'm looking at various indexes which may have to brought into 39B. And we do not know how many indexes are going to be there. To say that I'll look only a Marxist or a socialist index, and they're all dead for all practical purposes. Why should we go into it at all? But that is again a political philosophic, understanding. But I suppose if the Constitution has to do a journey beyond what we are seeing today, therefore, if we can probably wipe out many of the provisions in Chapter 4, because we are living in an open society of a free.
Look at it. Each word of the Constitution can have a different meaning at different points of time.
They can have.
That is what. So we cannot only think of what was there
Exactly.
in 1950s.
Exactly.
The same words can be interpreted in the 21st century.
Absolutely. Therefore, we are not, suppose we are talking about right to privacy, Article 21, a wide range of interests under Article 21. So I suppose all those values which go into an expansive constitutional interpretation are not to be confined only to certain provisions of the Constitution. They may have to probably inform the most important part of the Constitution, namely Part 4.
Certainly, we'll close now, I think, today.
Yeah.
And we'll start on Tuesday with the solicitor submission.
I have not touched upon 31C. We will have to probably, after the solicitor, deal with 39B.
We'll see if something remains, then we can
so 31C, we still need to come back to.
Yeah, I'll combine both, my lord, and assist your lordships in a composite way thereafter, my lord.
Or if your lordship permit me, I'll try to deal with 31C as quickly as possible.
Heard the broad drift of your submission.
Yes, yes.
We'll start with now the solicitor on Tuesday, and then Mr. Dwivedi will be arguing thereafter. Solicitor said you take about one session, right?
One session, maybe a few minutes here or there.
And then Mr. Gopal Shankar Narayan after Mrs. Dwivedi. Try and leave a little bit time for them for the rejoinders so that we can wrap up on Tuesday.
That I have responded. We will not repeat anything.
Besides, you are always Mr. Solicitor. That's why we are taking this liberty with you and Mr. Dwivedi. Trust us that we will not.
Your lordships are never, my lord.
But if possible, you can leave a little time for the rejoinders so that just the salient points they can state in the rejoinder. Then they can supplement it with a note also. No difficulty.
But if you lost permit me after Mr. Gopal Shankar and I need just 5 minutes, you lordship, for a small intervention, just 5 minutes.
Mr. Shankar Narayan is appearing for also the State of West Bengal.
Just
what about you?
Because I'm for an interview.
For an interview. We'll see how much time we have left.
Maximum 2 minutes.
So Tuesday is in the West Bengal matter.
In Mahada matter, my lord, he is appearing for the tenants, my lord, who will be opposing Mr. Devraj.
We will try and wrap up on Tuesday.
39B is the realization of common good by recourse to the resources of the community. To the extent such resources are under the ownership or control of citizens, the state is called upon to explore the common good and for that purpose deal with the ownership and control of resources in the hands of citizens. Once resources are in the hands of the state, no further questions about ownership and control issues will make sense. The reference to private resources in the order of reference, Honorable Court, may properly be read as a reference to human-made resources. That's what Reddy has in mind. So Article 39 is in the company of directive principles of state policy. It has enacted principles of social, economic, and political equality and the realization of an egalitarian social order. In Kasturilal, this court, Honorable Court has held, I read, it was pointed out by this court in Ramanadayaram Shetty that with the growth of welfare state, new forms of property in the shape of government larges are developing, since the government is increasingly assuming the role of regulator and dispenser of social services and provider of a large number of benefits, including jobs, contract, licenses, quotas, mineral rights, etc. There is increasing expansion of the magnitude and range of governmental functions as we move closer to the welfare state, and the result is that more and more of our wealth consists of these new forms of property. Some of these forms of wealth may be in the nature of legal right, but the large majority of them are the nature of privileges. Therefore, today we're talking of a very expanded understanding of new forms of property. Banking, insurance, the whole technology in several services, they're all new forms of property. And most of them are in the service of the community. So you snap good part of a technology and economy today, I think the whole organization of social life will collapse. So much of our economic activity depends on how do we harness human interaction, producing economic wealth and for the common good. While certainly the regulation and control, how we do it is a different question. Public interest must be, as far as possible, receive its orientation from the directive principle. But according to the founding fathers constitutes, the plainest requirement of public interest set out as the directive principle, and they embody par excellence the constitutional concept of public interest. If therefore any governmental action is calculated to implement or give effect to a directive principle, it would ordinarily, subject to any other overriding consideration, be informed with public interest. That's one shade of common good. Then state policy and fundamental rights are the two wheels of the same chariot. Please see so and so. I will skip these two paragraphs for the time being. I will come to para 8. As I come back to Minerva Mills, I'll read paras 56, etc. Then paragraph 8, in Lochner versus New York, Holmes with his dissenting note had observed as follows. But a constitution is not intended to embody a particular economic theory, whether of paternalism and the organic relation of the citizen to the state or of laissez-faire. It's made for people of fundamentally differing views, and the accident of finding certain opinions natural and familiar or novel, and even shocking ought not to conclude our judgment upon the question whether statutes embodying them conflict with the Constitution of the United States. That's why we're talking about the Constitution being read in more than one sense, and in an enlarged sense wherever the demands require. Now, paragraph 9. Having regard to the constitutional context in which Article 39B is located and its relevance towards realization of an egalitarian social order, any narrow or truncated reading of the provision may itself be offensive to the free play that is desirable in the working of the principle enshrined in Article 39. There is nothing in Article 39 which suggests of any limitation or qualification of the words used therein. The distinction between public or private resources or natural versus human-made resources is alien to the spirit of Article 39B and C. That's why I said we will not read into the Article 39 any economic, political, other categories or concepts which are not themselves found in Article 39B and C. Article 13B NC could not probably otherwise word it. They tried to convey a whole range of aspirations and principles of building an egalitarian social order. So it's not like drawing a statute. 39B and C is not like drawing a statute for a working purpose. So therefore, I started saying that unless we have in mind the whole historical background which led to the formulation of these ideas and principles, they have to be treated as signposts. And the signpost may not be said, I'll cross a line here on signpost. Then you will never understand the signpost. A cursory glance of cases decided by the Honorable Court with reference to Article 39B provides us an insight on the range of resources which have come up for consideration. For instance, in Banerjee versus Anita Pan, it's a case of freezing on suit for eviction by transferee landlord for 3 years. Then the next, I skipped Ranganatha serial number 2, and 3, Bhim Singh Ji is about land, Sanjeev 4 is about coke oven plant, which is then a processed mineral. Then serial number 5, Abu Kawan deals with a whole range of issues, but particularly stage carriage and contract carriage, which is on par with Ranganatha Reddy. Then 6, National Textile Corporation, assets of 6 textile undertakings, mills and industries. And they are obviously private properties and private resources. In Union of India West Cyanamide, it's a case of regulating drugs, pharmaceutical industry. Item 8, serial number 8, it's a case of regulating electricity as an industry. Constitution bench. Then Pathasarathi, serial number 9, where a company is issuing shares, Capital Control Authority were to regulate the share market. So shares as resource of the community. Then Orient Paper Industries. So you have a forest, you give a license to cut bamboos and then make them as a forest industry. Then 11, a refractory plant, again an industry, which is a true industry in the economic sense. Then item 12, we look at grant of dealerships of petroleum products. So it's a public resource, equality, to bring about equality in accessing public resources. So look at a wide range of resources which have to necessarily come within the ambit of distribution for common good. Then 13, land, 14 is about mines and minerals, 15 is again about a mining lease. So the whole law of mines have undergone a sea change now. And you still say auction or otherwise to allocate material resources to the community. Then Mafatlal, the case of refer excise duty, where they pressed into service 39D. I'll show all the judgment. Then 17 is natural gas. 18 is again a question of grant of natural resource. Then Coal India, recent judgment where Nagaratna was there. Then application of the Competition Act to nationalize coal companies. So how competition element is important even among public sector undertaking. 39B was brought into picture and it was discussed there. So I just gave a few illustrations to show that how the resources of the community will have to be understood from a very large framework of what will serve both individual, sectional, or collective good of the community. So sometimes it can be an individual need in the disabled part of a community who may require a certain technology improvement to serve them. So there has to be financial incentives. Which company will do that? I mean, regulate it. Therefore, the regulation and ownership and control will subserve not only that, when you talk of common good, it's not necessarily the entire national good. It can be the good of a certain section, an identified section of the community. And that's a state obligation. Wait, this is the other submission. I'll tell you what. turn to volume 2. Volume 2. Which one you want me to do? What we have done here, yeah, the shorter one was like a paraphrased one. This is a detailed one. I also appear for MADA, therefore it is done keeping that in mind.
Yes.
Yes. What I have done here is each paragraph, I'm sorry.
Page 38.
Page 38. I'll quickly, each paragraph refers to some judgment or the other to catch the, the wide meaning of resources which our courts have dealt with earlier already. For instance, in para 13 at page para 12, the idea of distribution of material resources of the community as prescribed under Article 39B is not necessarily limited to the idea of what is taken over for the distribution among the intended beneficiaries. I'll read each one of them a little later, just giving a broad overview. In para 13, the theme of the amended provision of the MHRD Act advances the social cause of the homeless families and the provisions contained therein can easily be classified as a socially beneficial statute. The courts on various occasions have expressed the reservation in striking down a socially beneficial statute dead unless a plain breach of the fundamental rights citizens is manifest. That's what Anita Pan says. That's just Anita Pan just before in Ranganatha Reddy. It just preceded Ranganatha Reddy. Para 14, courts have to ensure the directive principles are not to be dismissed with a mass of teasing illusion and a promise of unreality, curtailment in public interest of such extreme rights of the landlord as are read in tooth and claw is a constitutional compulsion. Then I'll skip Ranganatha Reddy for the time being to come back to it later. Let's just turn to page 40, para 19. There's a wide misconception that only the public utilities can subserve the common good and fulfill the objective of common good. It shall not be an understatement to aver that even a private resource may be for a national need and serve the common good. Article 39B of the Constitution should be construed in the light of Article 38 and understood as placing an affirmative obligation upon the state to ensure the distribution of material resources does not result in heightening inequalities among people and among regions. Then Article 39B envisages state shall in particular direct policy towards securing ownership and control are so distributed as to subserve the common good. Socio-economic justice read the arc of the Constitution. Public resources distributed to achieve that objective since liberty and meaningful right of life or age with availability of opportunities and resources to augment economic empowerment. We just look at it like that, and our opportunities created in the social world is not merely an opportunity for an employment in the public sector. So opportunities created by economic transaction, economic activities. So unless you have enough opportunities and equal opportunities, even outside the realm of the state, and that's where the ownership and control made itself. So the common good principle comes in. The mandate of Article 39B does not impose a restriction on the means adopted to subserve the public good and uses the word distribution, suggesting that the methodology of distribution is not fixed. When natural resources are made available by the state to private persons for commercial exploitation exclusively for their individual gains, the state's endeavor must be towards maximization of revenue. This alone would ensure fundamental rights in Article 14 and directive principles in Article 39B are extended to the citizen of the country. Then, in Jijubai, each word in Article 39 has a strategic role, and the whole article has a social mission. As a strategic role, yes. Each word in Article 39 has a strategic role, and the whole of article has a social mission. It embraces the entire material resources of the community. Its task is to distribute the resources. Its goal is to undertake distribution as best of the common good. It recognizes as a distribution the ownership and control of so-and-so. Term resource is a sweeping expression and covers not only cash resources, but even ability to borrow credit resources. Each one's judgments add on to a certain, facet of the understanding of resources. The word distribution used in Article 39B must be broadly construed so that a court may give full and comprehensive effect to the statutory intent contained in 39B. It should not be construed in a purely literal sense.
Mr. Attorney, come straight to para 27 of your written submissions. That's what
27, Your Lordship.
That's exactly what you want to convey. Where you have referred to Jijubai.
Yes.
Just come to that.
I'll read that.
And then you can conclude.
The material resource of the community is a wide concept, broadly interpreted to bring within sweep all resources, natural or physical, movable or immovable, corporeal or incorporeal, tangible or intangible properties, etc. Private resources or property are part of the material resource of the community. All things that produce wealth for the community. Why is it stated to be so widely, sweepingly made? Oh, as I've been trying to understand today, I think every little part of our life on an organized basis takes place by reason of a wide range of economic activities coming together. So when you say all that produce wealth, when you talk of wealth, for instance, in the early part of the 18th and 19th century, we talked about the wealth which is available as part of a land or a wealth you have produced and put it in a bank. Wealth today has no such, minimal connotation. So that's why we talk of different forms of property. Today we talk of emerging forms of property. So wealth must be understood in that sense, not merely monetary wealth.
Legal rights, correct?
And sorry.
Wealth would be in the nature of legal rights. The large majority of them are in the nature of privileges. They are just putting it to you.
No. Let me complete reading this. Because I thought while this was a very engaging issue, in the sense that you don't have a very pedestrian answer to it. You can't say, well, private resources are exempted from 39B. But then we don't answer the question, what are those private resources? How do they come about? Therefore, in Jijubai, they look at the larger way of understanding. Yes.
To go into these issues at this point of time.
We can. I'm trying to, why that we need to go into it is to say that 31C has lost its relevance in the sense that we are an open society, a free economy. We're not talking about a very outmoded Marxist notion of distribution of wealth. I don't think the court should look at it from that perspective. In the economic history of a country, we still have large mass of population who need to be brought succor to their life. So it's from that point of view, 39 was enacted, and we still have not traveled a good part of the journey. Therefore, to say that it has now lost its Marxist connotation, I think would be to look at only Marxism and leave everything else outside of understanding. That is the way probably then China would not have probably taken this course of regulated capitalism. So therefore, it's important for us to say that we will not halt or the arrest the progress of certain part of our constitution and leaving it in the responsible hands of the state to regulate the ownership and control of the resources to subserve the common good. Each one of them in a given context or a statutory context will be certainly scrutinized. There'll be certainly a judicial review of whether does it say a particular common good or a public good, or it's an illusory, common good talking about.
That's the core issue.
That's right. That certainly will happen. That tool is available in the hands of the court. But to say that, we will try to give a very narrow meaning to 39B and to curtail its broadest expansive understanding and the potential of its use in the hands of the state. in Jijubai, in that paragraph, they talk about providing access to equal opportunity. That's why, for instance, we have in the New Deal era in the 1930s, the Lochner era, they call it. So provision of economic opportunities for the racially segregated. So the US Supreme Court, I guess, should deal with them. So equal opportunity in the economic field. So accessing banking resources. So a wide range of resources today are evolving. So access to those who must act, for those people who are not able to access them on their own. So when Amartya Sen talked about the capabilities approach, he looked at a world where it can be probably brought by certain amount of state involvement in it. So unless I have the capabilities built with me, which can happen only if I have access to resources. So if I don't have access to the human housing resource, so what did Olga Tallis talk about? So if so you take away my life and therefore you take away my means of life, I take away my life. Shylock talking about in Merchant of Venice. So access to many things in life today depend upon how they can be made available by voluntary economic engagements and by state engagement. So the facilitating, the enabling environment can be built only when you have a certain understanding. But that does not mean the state can lay it very broadly. Lay it arbitrarily. That's a different area altogether.
Social and economic justice.
Yes.
Which is there in the preamble of the Constitution.
Your Lordship, please.
Justice includes social and economic justice apart from political justice. So it is in order to ensure that goal of the Constitution, we have this Article 39.
That's why you're entirely right. Therefore, we are talking of the amalgam, the interconnection between social, economic, and political dimension of a society. For long, we had this dialogue in human rights. The civil and political rights will have a precedence over social and economic rights. But then there is no longer a debate in human rights. They are part of one common human rights endeavor. Therefore, the interconnection between this, see, if 39B was to die a natural death, once Marxism was dead, it's a different answer altogether. I don't think we probably wish to give that answer. Maybe there are even contestants on whether Marxism is dead or not. I was thankful Chief Justice yesterday about Gandhiji's censorship issue. When there was a large amount of criticism about when Gandhiji made this, very interesting proposition. And there was a lot of potential about it. Whole set of Marxists criticized Gandhiji for saying that he's serving a bourgeois interest, to borrow a Marxist expression. But that's probably, we will move towards a whole amalgam of Gandhiji's censorship ideas, access to resources ideas, and how do we build them? Do we have a kind of a blueprint for all that? That's why every experiment in the economic field, every experiment in the social field, are all experiment to move towards, as it's called, the movement towards a better world.
The salutary nature of Article 39 as such.
Yeah.
The debate is when it is applied and the application which it has under Article 31C.
Yes.
I think you should go to the next chapter. Nobody is doubting the salutary aspect of Article 39.
No, when you are right, but if you are talking about a private resource immune from 39B, that's how the argument has been built. These are our private property. good part of it constitutes of livelihood or whatever it is. And therefore, they're removed from Article 13. There can't be any law which seeks to invoke Article 13(b) as a resting house. Therefore, it's important for us to understand this broader, canvas of 39(b). Then one can find out whether the law is good or bad is a different issue. Because from 1940 onwards, the rent has been frozen. And therefore, we really do not have the potential, enjoyment of the property. That we are in the particular context of a law. Whether that law is bad because of it closed eyes to a certain history, that is a different question altogether. But we are here trying to understand and settle the meaning of what 39(b) would actually take within its broad sweep. If it is read very narrowly, well, yes. If not, yes, then the implications need not necessarily be a matter for the court to think and say, if a law is made wrongly on an abusive understanding of 39(b), I don't think today, given the kind of limitations on lawmaking power and the competition in the political field, egregious wrongs will happen. May happen on the fringes, but not necessarily in the core of social governance. I don't think it's likely to happen. Of course, there are blunders which governments can make. Blunders for certain short-term political, whatever. We're not talking about that. We're talking about how do we read a constitutional provision. If one was to say that 39(b) has lost its vitality, we can say yes. Or if we had to say, no, provision like 39(b) can never lose its vitality. No, yes. So it can never lose its vitality because it has a kernel of importance for social organization and moving towards a better world. That's the kernel of 39(b).
We can come to para 37.
37.
Article 31C.
Yes. 30.
31C.
No, this 37 goes into a 31C argument. I propose to come to it a little later. As I have said, request the Chief Justice that since very incisive arguments have been advanced on 31C, and also with the contribution from all the Chief Justice, adding well to the understanding of this case, 31C. We need a little more time to reflect on that. It's not that we write one 31C like this and say we give goodbye to 31C. So it's
4 o'clock today as the conclusion.
I would like to look into it little more carefully to make any argument. Though all of us have some thoughts on 31C, but I don't think that should be like a thinking on the feet and then responding to it. It needs a certain reflection and a responsible reflection.
Clock today, Mr. Attendant. So
Huh?
we have to wrap up by 4 o'clock. So maybe the arguments will conclude at 4 o'clock. So please leave some time.
No, it's very difficult. Your Lordship, this is an important matter where two salient provisions of the Constitution are being debated. And 2.5 days on the other side, I could, of course, write a précis writing and hand it over to the court. But that's not what the probably court wants from the attorney and the Solicitor General. And we need the good deal of investment of our time and mind to assist the court in every possible way.
And it can't be finished, my lord. I'll just on a lighter note, my lord, there can be 2020, 1 day or 5 day. My lord, the fielding team should get as much time as the other team, my lord, got. My lord, we are fielding team.
All right, Mr. Attorney, can we just suggest one thing, that if you can wrap up by say 3:30 today, then we can start with the other.
My lord, I would need, my lord, about one session, my lord.
We'll see that, but if attorney completes by 3:30, we've got now the general drift of what the learned attorney has to say.
I will try to do that, but that's like pushing me to the wall.
So right now, till now, you are showing us the land,
Your Lordship, please. Sir.
showing us the land.
I only try to take off now. I know where to land.
Now you have to land.
I know that. I know, but I've not read, for instance, every one of us, by reading the same part of a judgment, has a certain way of reading it, a certain emphasis, looking at a particular word or expression and draw sense out of that. So I've not read quite a few judgments, which I would like to read them. But I'd like to say a broad outline. I thought that would be the best way of going about it to begin with. I was also trying to look at, I'll do that. Also, here, which one? The attention of the Chief Justice also on this very, very engaging subject of the more you draw it wide, what happens, the more you close it wide, what happens. And of course, it's one has to reflect on it. I looked at 39B very closely after this matter occurred. You look at every part of it. Either you treat 39B as having served a purpose for a period of time and fold it up and wind it up and keep it like in some constitutional mausoleum and keep it there. Or we say, no, it still has to have its vitality. Therefore, one looks at various expressions used in it. So like the common good use. So the common good, as we're trying to point out, as I said, an individual can also have a common good. A set of people who live, a tribal people, set of people, they have their common good. So protection of the minerals, as Samatha said, is a common good. The tribal has the material resources to be so distributed for their common good. Of course, ownership and control.
Attorney General, I think you have brought in the concept of distributive justice. That is at page 50, para 54. I think that is what ultimately you are trying to sort of canvas.
Paragraph, Your Lordship.
Para 54, just the heading of that, concept of distributive justice. I think when you talk about observe the common good, I think this is what you are trying to perhaps.
That's right. That's right.
Concept of distributive
justice. Your Lordship, sir. For distribution.
These are your words, but I think this is what your argument is, I think, geared towards.
This paragraph is an extract from Lingappa Pochanna. And I would say there's one part of it. Distributive justice, again, has often been seen as a liberal thought or a quasi-Marxist thought. I'm not looking at it from this very doctrinary economic understanding. So a distribution of a resource of a community today may have very imaginative understanding of that. So distributive justice in that sense, but how do you actually apply distributive justice today? How do you handle them today? So if you need a bedrock for that, let 39B remain as it is, with that larger connotation which we're trying to suggest to 39B. So that is para 54, distributive justice. Let me just quickly read it since your lordships are on that. It's at page
52, part of 52.
Page 52 bottom.
Quickly glance to it already.
I'm sorry. The concept of distributive justice in the sphere of lawmaking connotes inter alia the removal of economic inequalities and rectifying the injustice resulting from dealings and transactions between unequals in society. Law should be used as an instrument of distributive justice to achieve a fair division of wealth among the members of a society based upon the principle. I'm not talking about robbing Paul to give Peter. That's what the usual old dialogue against Marxism. I'm not talking about that. From each according to his capacity, each according to his, but again a Marxist credo. But the distributive justice in the constitution then means something else. Here claims of equality will be taken into account. The right to a private initiative, creativity, innovation, which is Article 19(1)G is about. So liberty is all about creativity and innovation. 19(1) is about it. So the state will have to maneuver amongst all these conflicting areas of, again, emerging fundamental rights. So if you're only at chapter 3, we have no difficulty at all. We only clash among fundamental rights. We can probably as well say chapter 4 has done its day, then pick up few provisions of chapter 4, and the rest of it can be given an exit day. That's not what can happen in a dialogue like this. The distributive justice comprehends more than achieving lessening of inequalities by differential taxation, giving debt relief for distribution of property owned by onto many who have none by imposing ceilings and holding both agriculture and urban of a direct regulation of a contractual transaction by forbidding certain transactions.
Distributive justice. Now we go to concept of socio-economic justice, para 60. Arc of the Constitution. Then rules of interpretation. Courts cannot adopt it. Doctrine of it. We can go now to para 62, UN report on public goods for economic development.
Paragraph 60 is only a summation of what is this socio-economic justice. In the previous paragraphs from 56 onwards, it's a little bit of a history about, you go back to Aristotle about what's a common good. So he talks about in Aristotelian understanding, then later medieval understanding, then Enlightenment understanding, later the socialist and other understanding. The common good has always received a wide range, but then ultimately it's about how do we organize our lives to requiring that our human interactions and economic transactions benefit not only a few, but everyone. So in a pre-industrial society, the things were different. So in a post-industrial society, it's going to be very different. In a machine age, it's going to be very, very different. Therefore, the importance of looking at it from a very, what called potential, a provision which has a lot of potential utility, and that can be invoked as flexibly as possible.
What is this UN report on public goods for economic development? Page 56.
Page 62.
Para 62.
I'll just compare it. Must have paragraph 62.
Yeah.
A common good or resource is one that can be exploited for private gain, but that no one owns. Free access to these goods bring up a basic management problem, since the criteria derived from private benefits do not coincide with those that public or intergenerational interest demand. Private benefits call for the most intense exploitation, while public or intergenerational interest demand the establishment of control mechanisms to preserve the resource. Thus, the characteristics of both non-rivalry and non-excludability can vary across classes of public goods. There are instances when an activity may simultaneously yield two or more outputs, called a joint products, some of them public or with different degrees of publicness. The degree of publicness varies according to the dimension and characteristics of the public effects. These joint products, such as education and biodiversity, benefit both those who receive them and the entire society by fostering more responsible social behavior. The idea of the public effects.
Now we'll see the common agenda report of the Secretary General.
Yes, I'll just do that. The twin concepts of the global commons and global public goods are used in various contexts and fields, including law and economics. The global commons usually refer to natural or cultural resources that are shared by and benefited all. They include the four conventionally understood commons that are beyond national jurisdiction: the high seas, the atmosphere, Antarctica, and outer space, all of which are now in crisis. Public goods are understood as those goods and services provided to and benefiting all of society, which at the national level may include street lighting, fire department, traffic control, or clean water. Certain public goods have long been acknowledged as being global in nature, in that they cannot be adequately provided by any one state acting alone, and they concern the welfare of humanity as a whole. These have traditionally ranged from global aspirations of peace, practicalities, civil aviation regulation, etc. Ultimately, what distinguishes these precise domains is that their protection is in increasing the task that can only undertake together. Then provisions of so and so, I'll just skip that. Then need to look at some of these statements in Sanjeev Kok and Ranganatha-Reddy in the sense that why they look at the resources very broad canvas.
Chapter 8A of the MADA Act, I think in the context of Article 14 argument is dealt with.
It is there.
Yes.
Yes.
I think that would be something of relevance.
But that's where I just want to hint at that, because the court is not called upon to decide the legality of that act here.
Classification.
Yeah, the geographical classification held as permissible classification, hence making provisions applicable only to the island city of Bombay cannot be held to be arbitrary and unreasonable. Such classification, therefore, cannot be held to be impermissible in excess with the objects of classification. Stopping here for a minute, as I said, any section of a community in any defined geographical area or a class of people with a defined aspiration, understanding, needs, demands, requirements. So therefore, the public good concept, the common good concept, all that will have to be woven into it in a way that we ultimately seem to serve the purpose of sharing the resources. That is not. Come to the first part of it here. The early part.
'74, salient features of chapter
Which one?
page 63.
Para 74, that is with regard to the act, page 63.
These paragraphs takes us in the details of the legislation and how it's not arbitrary, etc. So I suppose once the court sets the base for understanding of 39B, then any court who scrutinizes this act will look into that aspect.
What you're saying is that
I put them all there. I don't think I trouble the court with that. I'll trouble. Yeah, that's right. That's right. That's right. So why did Ranganatha-Reddy go into this question and Sanjeev Kok thought Ranganatha-Reddy was a clear case where a transport service, nationalization of transport service is now part of our national economy, and every state has done that. Now they coexist today, they're private and public transport services. And whether they do well or not is again a different question. You may have all kinds of accusations against the poor quality of a public service. The same can also be extended to private services. I think there's nothing different about it.
Thank you, Mr. Attorney. With your usual characteristic precision, you're finished 10 minutes before your allocated times.
I would like to read Ranganatha-Reddy because it's and Anita Pan, Ranganatha-Reddy, then I'd like to come to Mafatlal to quickly say that it is not an arbiter. It's not an arbiter at all. There's 9 judges sitting together looking at Sanjeev coking coal, what had happened earlier. And they say, look, and then the counsel raised an argument before the court. Look at these aspects of this case.
Mafatlal, I will cover. Other two you can cover.
Yes, Mafatlal, you are.
Mafatlal, I'm talking about Mafatlal. Sorry.
Mafatlal, there is just one paragraph, para 86.
83, 84, 85, 86 of Mafatlal.
Cover other points. Cover other two.
So kindly give me Ranganathan.
First, Anita Pan.
Anita Pan.
Anita Pan is involved.
Now again, read Ranganath Reddy. If you can just tell us the point that you're making, we'll make a note of it.
Can you read Anita Pan, volume 5D, page 154.
The paragraph number.
5, 6 and 52.
This is volume 5D, page 156 or 154? 156.
Check 1. And 32, and this statement was my question earlier.
At page 160, PDF 162.
Volume 5D.
This was a case of a Rent Control Act.
This is volume 5D.
Paragraph 6, page 162,
Volume 5D.
volume 5D. Some background observation to appreciate the context in court are necessary. No social realist will deny the frightful dimensions of the problem of the homeless families and precarious tenancies, and if the directive principle, state policy are not to be dismissed by the mass of the teasing illusion and a promise of an reality.
Volume 5D.
Volume 5D.
President.
of that page?
Starts with some background.
Yes.
That's right. Some background observation to appreciate the context, and no social realist will deny the frightful dimensions of the problem of homeless families and precarious tenancies and leaves the directive principle, their policy are not to be dismissed as a mass of so-and-so. Curtailment in public interest of such extreme rights of the landlord as a ready in tooth and claw is a constitutional compulsion. The court, informed by the sore economic situation and reinforced by initial presumption of constitutionality, hesitates to strike a socially beneficial statute dead, leading to escalation or the mischief to suppress with the human high house legislated, unless, of course, a plain breach of fundamental right of the citizen is manifest. Which is the paragraph. Then paragraph 8. The explosive import of neglecting such a distressing urban development reasonably obliges the state to impose drastic restrictions on landlord's right to property. And when circumvention of wholesome legal innovation is practiced, in large scale, the new challenge is met by clothing the law with more effective armor, and that is the rationale of the Amendment Act. The learned judge rightly referred to the legislative preceding, notorious common knowledge, so and so brought in the can. The soundproof theory, ignoring voices from parliamentary debates, once sanctified by British tradition, has been replaced by the more legally realistic and socially responsible canon of listening to the legislative authors when the artifact is being interpreted. We agree with the High Court when it observes. Then kindly turn to paragraph 12. Paragraph 12 at page 165. This is an example of how the court may look at it, not by holding lenses with a narrow approach, but law, so and so, etc. We emphasize this fact of sociological jurisprudence because the High Court struck down on surmises, possibilities, and maybe rather than on the study of actualities and proof of the nature and number and age of pending litigation got in the respect of so and so. Judges act not by hunch, but on a hard fact properly brought, sufficiently strong to remove the initial presumption of constitutionality of legislation. As the court of the chamber or the House to weigh whether it should legislate prospectively or draft the clause differently. We find no foundation of the large assumption, so and so, etc. Yes. It's over. This is over. One. Right. Not getting it.
Mr. Chetan, we'll have a look at the judgment. ysjaganmohanreddy. Then give us a small note, maybe later on.
37.
This is the one where they don't agree with.
Page 1749, volume 5.
This is the one where they disagree with Krishna.
4 plus 3 in Ranganath Reddy is to be seen as 4 plus 3, not 4 minus 3. In the sense, as Untwala is saying, we've not taken to concur with Justice Krishnaya. Here is what they say in paragraph 37. End of paragraph 37. Our learned brother Krishnaya has prepared a separate judgment specifically dealing with this point. What's the point about? The transfer of certain funds which have been taken from the secured creditors, and whether 31C will cover that issue. Therefore, the judges say that is being dealt with separately. And then Krishnaya judgment himself at page 1750.
That is why Justice Untwala.
We go only with our learned brother Untwala.
That's why he said that we must not be understood to agree with all that he has said in that judgment in there. Normally, you give a dissenting judgment and that remains.
That's right. But the judges understood as far as 31C is concerned, there's another opinion. I understand it, everybody having agreed on that.
No.
In the common theme of the judgment. I'm talking about the common theme of the judgment.
No. In fact, my lord, what Justice Krishna here understood to be a concurring opinion, Justice Untwala say is in fact a dissenting opinion. In a different way. Very clear that we should not be understood that we have agreed to that. Agreed with all. Yes.
All that he has said. Now, I'm trying to look at it like this. The court is called upon to answer a question whether nationalization of a transport service would fall under 39(3). See, that was the main question. So the act was upheld. The act is upheld, which means it doesn't fall foul of any constitutional provision. Whether on the expanded logic of 39B, natural resources meaning or not, act has been upheld. That's what I'm trying to say. Therefore, if 39B expand, a meaning has to be given to support the outcome of the judgment. Krishna has endeavored to do that. If you look at 39 at all, you have to look at it. One seven. One. So, kindly just pick up only a few paragraphs, Lords. Kindly at page paragraph 79, at page 1770. Majority view and so settled with the court and stated. Lords, to skip a few lines and a little later. Article 31C has also been upheld, subject to the rider that there should be no nexus between Article 39B and C
Should be
and the object of the acquisition. That's right. Should be. Our learner also has struck a middle note and pointed out that where the inputs of valuation prescribed with statute are only irrelevant or unconnected with a social good, then Article 31(2) may not retrieve the statute. It's a far cry from this observation to the position that the 25th Constitution Amendment leaves untouched the ratio in Cooper. You pointed out how the said constitutional amendment was expressly undertaken inter alia to undo the effect of Cooper and to forbid forensic diagnostics into the question of compensation. In this light, it is difficult to uphold the view of the High Court that Cooper survives after death and keeps virtually alive the obligation of payment of market value inclusive of usurious rate of interest and all that. Then next, kindly turn over to paragraph 81. Resources is a sweeping expression and covers not only cash resources, but even ability to borrow. Its meaning given in Black's dictionary. And keeping that dictionary meaning, and material resource of the community in the context of reordering the national economy, embraces all the national wealth, not merely natural resources, all the private and public source of meeting material needs, not merely public possessions. Everything of value or use in the material world is a material resource, and the individual being a member of the community is a resource as part of the community. To exclude ownership of private resource from the coils of Article 39B is to cipherize its very purpose of redistribution, the socialist way. A directive to the state with deliberate design to dismantle feudal and capitalist citadel or property must be interpreted in that spirit, and hostility to such a purpose alone can be hospitable to the meaning which excludes private means the production of goods produced from the instruments of production. AKSN agrees that the private means of production are included in the material resources of the community, but by some baffling logic excludes things produced. If a car factory is a material resource, why not cars manufacture? Material may cover everything worldly, and resources according to so-and-so takes in the collective wealth of a country or its means of producing wealth, money or any property that can be converted into money assets. No further argument is needed to conclude that Article 39B is ample enough to rope in buses. The motor vehicles are part of the material resource of the operators. Which is the next paragraph. Then paragraph 83. 83. 1772. Two conclusions strike us as quintessential. Part 4, especially Article so-and-so, is a futuristic mandate to the state with a message of transformation of the economic and social order. Firstly, such change calls for collaborative effort from all legal institutions, systems, the legislature, judiciary, and the administrative machinery. Secondly, and consequentially, loyalty to the high purpose of the Constitution, that is social and economic justice in the context of material want and utter inequalities on a massive scale, compels the court to ascribe expansive meaning to the pregnant words used with a hopeful foresight, not to circumscribe their connotation into contradiction in the objective inspiring the provision. To be parasitic towards the Constitution through ritualistic construction is to weaken the social, spiritual trust of the founding father's dynamic faith. When Krishna talks about the social, spiritual trust, probably he also has in mind Gandhiji's trusteeship.
Please read paragraph 88.
What? I'll just come. That's a conclusion.
Yes, that is very important.
There is another stark possibility. Now, before that, para 87 also, Lords may just make a note. Legalism has yielded to when spacious issues arise. Whatever the legal aspect of the thing, there are moments when it's feeble read to rely on so-and-so in the Constituent Assembly. There's another stark possibility, the administration sliding back from the progressive constitutional values to the protective private interest, and the court may activate the welfare jurisprudence of the Constitution by appropriate commands. While